I've seen a lot in my years on the bench. I spent decades in Manhattan family court watching people do unspeakable things to each other and then lie about it with a straight face. I thought I'd seen every flavor of human dysfunction this world had to offer. Then two sisters walked into my courtroom, and I realized I hadn't seen anything yet. If you believe that blood doesn't make family, accountability does, drop a comment below right now and subscribe, because this case, this one you will not forget. The plaintiff's name was Diane, 52 years old, retired school teacher. She walked in wearing a sensible blazer, reading glasses pushed up on her head, and the kind of quiet exhaustion that doesn't come from one bad week. It comes from years, decades. She was suing her younger sister Pamela for $50,000. In my arbitration courtroom, the cap is that number, and she'd claimed every penny of it. Pamela walked in 2 steps behind her, 48 years old. Louder posture, louder outfit, louder everything. She was already shaking her head before she even reached the podium. I clocked that immediately. When someone is shaking their head before the case has started, they're not confident. They're rehearsed. There's a difference, and I know it after 30-plus years of watching people perform innocence. I said nothing. I let them settle. I looked at my paperwork. Hit that like button if you believe the first 30 seconds in a courtroom tell you more than most witnesses ever will. The complaint was straightforward on paper. Diane alleged that 20 years ago, 20 years, she had loaned her sister Pamela a sum of money to help Pamela purchase her first home. The original loan, $30,000. Diane claimed she never received a single payment back, not one. The interest she was claiming was modest. She wasn't being greedy, but with compounding and the years involved, she had landed on $50,000 as her ask. Now, I want you to sit with that for a second. 20 years, that's not a short-term memory problem, that's a lifestyle. I leaned back in my chair and looked at Pamela. She was already sighing. Already. The case hadn't started. I said, "Miss Pamela, I haven't asked you anything yet. Whatever expression is on your face right now, save it. I'll give you plenty of opportunity to use it." The bailiff, my longtime bailiff, Marcus, pressed his lips together. That's his version of a laugh. I turned to Diane. "Tell me about this loan." And here's where it got interesting immediately. Because Diane didn't launch into a speech. She didn't cry. She opened a folder and she slid documents across the counter. A handwritten agreement, dated 20 years ago, almost to the month. Both signatures on it, a copy of a bank wire transfer, $30,000, Diane's account to Pamela's account, clean, clear. I looked at that paperwork and I thought, someone came prepared. That matters to me. That matters a great deal. I asked Pamela, "Is that your signature?" She looked at it like it was going to bite her. "I mean, it looks like it." "Does it look like it or is it?" Pause. "Yes, it's mine." Now we were getting somewhere. Before I tell you what I found next in that paperwork, subscribe. Because this case goes somewhere nobody in that courtroom expected, and you are not going to want to miss the turn. Pamela's defense, as she presented it, was layered. Layer 1, she claimed the $30,000 wasn't a loan. It was a gift. She said their mother had encouraged Diane to help her. She said there was a family understanding that Diane, being the older, more established sister, was simply doing what family does. I let her finish. Then I picked up the handwritten agreement and I read it aloud, slowly. I, Pamela, and then her full legal name, acknowledge receipt of $30,000 from my sister Diane as a personal loan to be repaid in full with agreed interest within 10 years of this agreement. Signed, dated. I set the paper down. Miss Pamela, that is the definition of a loan. Not a gift, not a family gesture, a loan with a repayment window. Does that sound like a gift to you? She said, "My sister was pressuring me." I said, "I'm speaking." Silence. "You signed this document. Do you dispute that signature?" "No." "Do you dispute the bank wire transfer showing $30,000 moved from her account to yours?" Another pause. "No, but I didn't ask for a but yet. I'll ask when I want one." The clerk, Janet, she's been with me longer than I care to admit. She glanced up from her notes. That look she gave me said, "This is going to be a long one. Share this if you know someone who confuses a loan with a gift the moment repayment comes due." Now here's where the story shifted. Because Pamela's attorney, she had one, a young man who looked like he'd graduated law school sometime last Tuesday, he submitted a counter exhibit, and it was a letter, handwritten, from their mother. Their mother, apparently, had passed 3 years ago, and this letter, dated about 12 years back, was addressed to both daughters. In it, the mother wrote, and I read every word carefully, that she wanted both girls to live in peace. That money had divided the family, that she hoped Diane would release Pamela from the burden of the loan because, quote, Pamela has been carrying enough. I read that letter twice. The courtroom was quiet. Then I looked at Diane. Her jaw was set. She was looking straight ahead. I asked her, "Did you know about this letter?" Her voice for the first time cracked, just slightly. "My mother showed it to me, once, right before she passed. And I told her I loved her, and I told her that Pamela and I would work it out." "Did you ever discuss forgiving the loan with Pamela directly?" "No." Diane cleared her throat. "Because 3 days after my mother's funeral, Pamela filed to refinance the house. She took out equity. She went on a vacation to Italy with her boyfriend. I saw the photos on social media. I didn't say a word. But that's when I knew." I leaned forward. "Knew what?" "That my mother's letter was Pamela's exit strategy, not my mother's wish, Pamela's plan." The room got very still. If you've ever been used by someone you loved, leave a comment. Because what I was about to uncover made even me go quiet for a moment. I called a brief recess, not because I needed one, because I wanted to look at the timeline without an audience watching my face. Sometimes as a judge, you need 30 seconds of private thought before you deliver the next question, because the next question is the one that breaks the case open. I went through the refinance documentation Diane had submitted. The house Pamela purchased 20 years ago with Diane's $30,000, that house, according to current county records, was now worth $410,000. Pamela had refinanced twice. She'd pulled out equity both times. She was currently sitting on a home she never could have bought without her sister's money, a home now worth over $400,000, and she had not paid back 1 single cent of the loan that made it possible. Not 1 cent. I came back to the bench. I looked at Pamela. "Let me ask you a question," I said, "and I want you to think before you answer." She nodded. "In 20 years, did you ever, once, send your sister any amount of money toward this debt? $100, $50, a card that said, 'I haven't forgotten,' anything?" The hesitation was answer enough, but she said it anyway. I thought, "I didn't ask what you thought, I asked what you did." Silence. "Nothing," I said. "You did nothing." Her attorney started to rise, and I stopped him with a look. He sat back down. "Here's the thing about 20 years of silence on a debt. It doesn't make the debt disappear. It makes the person owed money wonder whether they matter at all. Diane didn't need the $50,000 to buy groceries. She was a retired school teacher with a pension. She needed it because it was the only way left to ask her sister, 'Did any of it mean anything to you? Did I?' Subscribe to see more cases where the truth underneath the lawsuit is bigger than the dollar amount on the complaint." Pamela tried a new angle. She said Diane had borrowed money from her too over the years. Small amounts, birthday gifts that turned into loans, apparently. Her attorney slid over a handwritten list. I looked at it. The items were things like, lent Diane $200 for car repair, 2009. Covered Diane's half of Mom's birthday dinner, $85, 2014. I looked at that list. I looked at Pamela. "Baloney," I said. Her attorney blinked. "You're comparing $200 for a car repair to $30,000 for a house down payment? Don't pee on my leg and tell me it's raining." Someone in the gallery actually laughed. I didn't react to it, but internally, I appreciated it. The list was irrelevant in terms of offsetting the debt, but it was very relevant in terms of telling me who Pamela was. She was the kind of person who kept score on small things and conveniently forgot the big ones. That's a character portrait right there. I've seen it 1,000 times. The person who reminds you of the $85 dinner and never mentions the $30,000 foundation their entire adult life was built on. Then Diane said something, quietly, almost to herself, but I heard it. She was my maid of honor. I looked up. "My husband passed 11 years ago," Diane said. "I raised 2 kids on a teacher's salary. I never asked Pamela for a thing. Not when David died. Not when I almost lost my house. Not once." The courtroom was absolutely silent. I looked at Pamela. She was looking at the podium. I thought, there it is. There's the whole story, not $50,000. 20 years of a sister who gave everything and got silence in return. Before I tell you my ruling, hit that like button. Because what I decided came down to something more complex than a signed agreement, and you deserve to see the full picture. Here is what I knew to be true by this point. The loan was real. The signature was real. The wire transfer was real. The debt was real. Pamela had never paid a single cent and had, in the intervening 20 years, built substantial personal wealth on the foundation of that unpaid loan, a home now worth more than $400,000. I also knew something else was true. The mother's letter was real, and while I believed Pamela had used it strategically, that letter did exist. It was written by a dying woman trying to hold her family together. That mattered to me. I did not believe the letter constituted a legal release of the debt, not even close. A parent cannot unilaterally forgive a debt between two adults in a private letter. That's not how any of this works. But it told me something about the family history, that these two women had been circling this wound for over a decade, and that their mother had known it and tried to close it, and it hadn't worked. I called Pamela back to direct examination. "Have you ever apologized to your sister?" I asked. She looked surprised. "We're family. We didn't really—" That's not an answer. I thought she understood. Understood what? That I was grateful. I let that sit in the air for a moment. Then I said, "Miss Pamela, gratitude without action is just a feeling. It helps you sleep at night. It doesn't pay anyone back." That's one for the replay button. I knew it when I said it. Now, here is where my thinking landed, and I want to walk you through it because this is what 30 years of family court experience looks like in practice. The claim was $50,000. The original loan was $30,000. The contractual repayment window in their handwritten agreement was 10 years. That window had long since closed. Pamela had not made a single payment. She was in full default. The interest calculation Diane presented was actually conservative. However, and in this job there are always howevers, I was sitting in an arbitration courtroom, not a bank. I was weighing human reality alongside legal obligation. Pamela was not wealthy. Her home had equity, yes, but she had her own financial obligations. An immediate $50,000 judgment would be crushing. And here's the thing I kept coming back to. Diane wasn't here for the money. She was here for an acknowledgement, an answer to the question she'd been asking in silence for 2 decades. Does what I did for you matter? So I made a ruling that I believe was right, fair, and actually functional. Share this with someone who believes accountability and compassion aren't opposites, because they're not. That's a lie people tell themselves when they want to avoid consequences. I awarded Diane $42,000, not $50,000. I reduced the claimed interest slightly because I took into consideration the mother's letter as a document showing the family context, not as a debt release, but as a factor in the calculus of fairness. $42,000 to be paid in structured installments over 36 months, with a lien placed on Pamela's property as security. If she missed a single payment, the full remaining balance became immediately due, and I would not be sympathetic. Pamela started to protest. I raised one hand. "I'm speaking," she stopped. "You borrowed $30,000 from your sister 20 years ago. You signed a legal agreement. You built a life on that foundation. Your sister raised 2 children alone, never asked you for anything, and never received a single payment. You owe her this money, but I'm not here to ruin you. I'm here to make you responsible. There is a difference. You have 36 months. Use them wisely." I turned to Diane. "You did something generous 20 years ago for someone you loved. You were right to do it, and you were right to come here. The truth matters. And in this courtroom, it costs something when you ignore it." Her eyes were wet. She didn't let them spill. I respected that. Subscribe if you believe that the truth, told plainly with evidence, without drama, is still the most powerful thing a person can bring into a room. The hearing closed. Marcus, the bailiff, gathered the paperwork. As Pamela walked out, she stopped, just for a moment. She looked at her sister. Diane didn't move. Pamela opened her mouth, closed it, walked out. I watched that. I've watched moments like that for 30 years, the almost apology, the pride that costs more than the debt ever did. I've learned not to be surprised by it, but I've also learned it never stops being a little heartbreaking. A few months later, Janet, my clerk, told me Diane had sent a note to the courthouse, just a few lines. She said the first payment had arrived on time. She said Pamela had included a card. No apology exactly, but something. A few words that acknowledged the past. Diane said it wasn't everything, but it was a start. That's the truth about family betrayal. It rarely resolves in a single dramatic moment. It resolves, if it resolves at all, in increments, in small choices, in a card attached to a check that arrives on time. Let me tell you something, because this is the part of my job nobody talks about. Every case I hear is really about one question underneath all the facts. Do I matter to you? The money, the property, the contracts? They're just the language people use when they can't ask that question directly. Diane couldn't look her sister in the eye and say, after 20 years, do I mean anything to you? So she filed a complaint for $50,000 and she walked into my courtroom with a folder full of evidence and she asked it the only way she knew how. That doesn't make her weak. That makes her human. And Pamela? Pamela told herself a story for 2 decades. The story was, Diane gave me a gift. The story was, Mama said it was okay. The story was, I deserve this because I've had it hard too. But the paper said loan. The wire transfer said $30,000. And 20 years of silence said everything else. If it doesn't make sense, it's not true. And a $30,000 gift from a schoolteacher sister? No paperwork, no follow-up, no acknowledgement. That does not make sense. Not for a single day. Tell me in the comments, what would you have done? Would you have awarded the full $50,000? Would you have used that mother's letter differently? I want to know. Because every person who watches this has a family, and every family has a Pamela, and every family has a Diane. You know which one you've been, and you know which one you want to be. Hit that like button if you believe a debt, financial or emotional, should be honored. Subscribe to this channel if you want to keep seeing cases where the truth finally gets its day, and share this with someone in your life who needs to hear that accountability and love are not mutually exclusive. They never were. I've been doing this for a long time. I've seen grief weaponized, love exploited, signatures denied, and bank records rewritten in people's memories to suit whatever story they needed to survive. I have seen people walk into this courtroom as victims who turned out to be villains, and I have seen people who looked like troublemakers turn out to be the only honest person in the building. This case had neither a villain nor a saint. It had 2 sisters, a dead mother, a signed piece of paper, and 20 years of a wound that nobody wanted to dress because dressing it meant admitting it was there. The wound was there, it needed dressing. That's what I'm here for. But nothing, absolutely nothing, prepared me for what walked into my courtroom next.